Any mentioning? Step ladder. Onboarding ladder. Item number 1.
Wait, please.
No, please.
But item number 2 and 3 would anyone here to start with?
Act number 2.
Let me briefly remind my lords of the controversy. This was a case where the statute does not provide for procedure under section 148A to be followed. And there's an exception. And they have taken that route to because this information was obtained under a scheme made under section 135A. So if my lord is pleased to have that section once more. Kindly first have section 148 subsection 3 clause IV.
148.
Subsection 3
Yes.
clause IV. It says for the purpose of this section and section 148A, the information with the assessing officer which suggests that the income chargeable to tax as escape assessment means, and then clause 4, any information made available to the assessing officer under the scheme notified under section 135A.
Yes.
And then section 148A, subsection 4.
Yes.
The provisions of this section shall not apply to income chargeable to tax escaping assessment for any assessment year in the case of an assessee where the assessing officer has received information under the scheme notified under section 135A. And note that 135A itself, if my lord please to see, 135A is the faceless collection of information.
Yes.
Under this provision, there's an e-verification scheme of 2021, which is at page 504 in volume 4, under which that information is collected. It is the annual information statement from various sources. That information goes, and based on that, the collection is there under that particular scheme. So here I will show from the record that the starting point was the annual information statement about two things. One was that tax had been deducted at source from about 264 odd crores paid to me under the provision relating to rent. And there's an income tax interest payment to me of some 44 odd lakhs. So those were the two things they picked up from that annual information statement. And based on that, there's a section 133(6) notice, and then a response was given. And so that is how the scheme is being implemented, this particular e-verification scheme. And there's an instruction of the board dated 11th March 2025, at page 508, which is how the authorities should conduct themselves in this regard. Now, adverting to the facts, the petitioner has set up this uh, uh, as a developer of special economic zones, the information technology parks in the special economic zone, in respect of the income which is earned as a developer, there is a deduction available under section 80I AB to the extent of 100% of the profits. So the normal tax liability comes under the book profit provision. Because the under chapter 6 that deduction is 100%. So therefore, they ultimately pay tax on the book profit. So this particular amount which is received by the assessee after deduction of tax at source. So the assessee has been showing the entire amount as business income, because it says that it is in the business of developing these in the special economic zones in terms of that provision. So there have been scrutiny assessments under section 143(3), at least for 4 years, where this particular position has been accepted, this particular income has been assessed under the head business, and the credit has been granted of the tax deducted at source. There is one assessment which was under section 143(1). So assessment is 16-17, 17-18, 18-19, and 2021. These are all the orders are annexed. They are all under section 143(3). My lord will find them at page volume 1, page 107.
Yes.
The first one at page
1670.
Yes, kindly see at page 107, the last line. During the year under consideration, it has been submitted that RGA, that's the SSE, is in the business of infrastructure development of the kind specifically used by ITES companies. RGA has developed IT parks as per IT Park Scheme 2002, notified by the Department of Industrial Policy and Promotion, White so-and-so. RGA has also developed special economic zones for IT and ITS as specified and notified by the Government of India under the SEZ scheme. As per the above approvals, RGA also operates and maintains the infrastructure created as per the requirement of the Act, receives all revenues from renting of removed property and towers maintenance of the facility. RGA leases out IT office space with 100% backup power, chillers installed in each of the facility, sewage treatment plant, water treatment plant provided for each of the facility, and RGA maintains the infrastructure through annual maintenance contracts awarded for all plant and machinery and provided for security, housekeeping arrangement 24/7 at all the IT parks in SEZ. Assessee also submitted that RGA has developed IT park at Electronic City and SEZ space, and it was let out. Income whereof is offered for taxation under the head income from business. We are claiming the said income deduction under section 80I and 80IB of the IT Act. Then speaks of the approval, then the penultimate paragraph. Further, the company has been provided the status of co-developer of pre-tech SEZ by the approval letter so-and-so. Since the company developed in the SEZ space, the income of the company from SEZ is deduction under section 80IB. So these are the factual assertions made, and my lord will find it at page 117. The computation is there, my lord. Page 116, the last line, going on to the next page, gross total income as per ITR. Now, the associate said that it is offered its income under the head business. Gross total income, then whatever disallowances, etc. Then, middle of the page, less deduction claimed under section 80IA and 80IB, 74 crores. So then, book profit is 79 crores. On that note, the tax is being paid. Now, the next year, if my lord is pleased to have page 119, at page 120, the first new paragraph, that business is described again, which is there in the earlier year also. And Then note at page 123, 122, if my lord is pleased to have, the gross total income as per ITR computation was 83 crores. Note, page 123, deduction under section 80I-AB, 72 crores, taxable income. Then note the book profit is where the tax comes in. And note the breakup of that, and kindly have page 125 as to where that income alert is being put. No, that is in the computation sheet. Note page 125, note, serial number 2, income from business or profession 83 crores. Because not also he writes as per return, but so we do not get to know from that what the return was. So note he has this note the assessment is made, and at page 126, note at the top, serial number 12, total deduction under chapter 6A, 72 crores. So that is now note the can you see note page 130? So this is for the assessment year 2018-19. My lord will find out it was selected for, at page 130, it was selected for complete scrutiny assessment under e-assessment scheme 2019 on the following issues. Not the third one, 80IA, 80IAB, no, those are the deductions claim was one of the reasons not why it was selected for scrutiny. And then look at page 131, paragraph 5. The assessee is a company. Assessees engage in the business of infrastructure development of the kind specifically used by the ITS companies. Assessee has developed special economic zone for ITS as specified and notified by the government of India under the SEZ scheme. Then 7, with the above remarks, return income of so-and-so declared by the assessee is accepted. Since the MAT liability of the assessee is greater than normal tax liability, tax is charged at the MAT income under section 115 JB. And then here again at page 133 in the computation, my lord will find that it is under the head business.
Yes.
Now the next similar 1920 was under 143.1. That page 138, 139. And there again, it is, my lord will notice, it is serial number 2, page 138, business side.
Business.
And with the deduction note at page 139, serial number 12, B, part C, chapter 6A, 97 crores. And ultimately, under serial number 19, it's book profit under section 115 JB, 102 crores. The tax is computed with reference to that. The last year note is at page 1, it's in volume 2, note, page 151, assessment year 2021.
151.
151. At page 152, the second new paragraph. The nature of the business note is taken note of as in the other years note. It's developed that those in the special economic zone, and then its revenue from renting and towards maintenance. that computation sheet is not there for this semester. Now then, our assessment is 21-22, and the return for this semester starts in volume 2 at page 162.
162.
Lodge.
Yes.
Kindly have a look at total income, 13 crores 40. This is after the deduction. The book profit under MAT is 179 crores. The net tax payable is 31 crores 34 lakhs. Taxes paid is 31 crores 69 lakhs. And then there's a refund of 34 lakhs, 31 crores, refund dues of 34 lakhs. This is the acknowledgement of the return. But may I quickly take my note to some of the portions here, just to show what was the figure in the return, because they have the allegation in the notice or the approval with the notice is that I have kept an entire sum of 264 crores out of my books of account. So and that is the reason why they say that is they say that tax has been deducted at source from this amount of 264 odd crores. And the query which came to me was, have you shown it under the head income from house property? My answer was that I have shown it under the head business. It is all there. So and that this is all
business itself is house property.
Yes, and that in the past it has also been so assessed. So I would think that they have actually ignored my response and gone on to say that this entire amount is out of the books. Normally, income tax interest which I have received from the income tax department, even that is suggested that I have kept it outside the book. Books were never called for. He had no opportunity to see, because the credit which is appearing in the annual information statement, that is the same credit which I have claimed in the return. If they had cared to check the credit that I have claimed, it is the same credit. The law is not, I'll get credit in the year in which that income is assessable. So I have shown the income. That is a total figure, of course. But the 26, the TDS is, they have the full details, and that is I'll show it to some 22 odd crores was the TDS.
So income from house property would be taxable in a case where the assessee has business other than house property. If he himself has business of infrastructure development, or he is dealing with property or house property, whatever the expression may be, he would not be separately taxed for that. It will be his own business, and he'll be taxed for business only.
But if I may just clarify this part, not where it is a letting simpliciter, not where I give the key to the room, not an office space, or a flat, a residential flat. But it is renting simpliciter, it will go under the head house property only. But
and if I have that business only.
Yes, and here the business is not simply it is putting up the infrastructure also. There are so many services also. So therefore, the whole thing is regarded as a business, because it's not simpliciter a letting. It's a composite activity, and the composite activity it's a complex letting, and therefore complex letting is not regarded as house property income. So for example, a cinema hall. It has one leases out the cinema hall, but it's not it will not be assessed under that house property. A storage vault, a safe deposit box. Those are they are equipped places. They serve a particular business purpose. So therefore, the assessment is under the head business. And the section itself, the ATIAB says that it will be the income will be the deduction will be allowed in respect to the income of the developer from this particular development activity. And when I set it up, I also maintain it, operate it. Of course, the users are different people. So that is how I just wanted to show from the return as to what were the figures of the revenue which was disclosed in the return, what is the TDS credit which is claimed, and then I'll take my note to the 133.6 which was issued to me, the notice, my response to that, and but the conclusion which they have arrived at, without hearing me or looking at my books of account, is that I have kept it outside the books of account, they say. And that is not a conclusion which could not have been arrived at under any circumstances. Similarly, Therefore, this challenge,
Those is at a stage of section 148A3, or they
Well,
have
the-
proceeded further.
the one, because here that 140A is excluded. So I have actually filed objection after the notice came.
So direct 148
Yes.
notice issued and proceedings are on.
Yes, so therefore, I filed the objection, on the
The
principle of the,
objections were not disposed of.
yes, they are, so, therefore, my lord, found
Yes,
that
yes,
this was,
I quite get it.
lordship.
That GK and drive shafts principle, why it should not be applied in
Lordship.
such cases.
There are, why I was troubling my lord with the facts here was because, there's a judgment of the Honorable Bombay High Court. Quite on, of course, under the previous set of provisions, the provisions that came in 2021, because there have been some changes. Similar provisions to the effect that 148A procedure need not be followed because of information collected under that scheme under section 135A. So the court was pleased to hold that when you've asked a query from the assessee and assessee is given an answer, you cannot then go ahead and under section 148 without looking at it. So you have to then consider it, and you have straight away gone to the 148 and put them to all these proceedings. So the court was of the view that in such cases it is better to take the 148A route rather than to, and therefore the question of wiries, which we have raised here, and also there it was raised, the court was pleased to not go into it. Particularly on the facts of that case, the revenue accepted that there had been a mistake, that they had taken the wrong figure. Because that e-verification scheme, it's not the how many people are looking at things in what way, but it is not really known, because it goes from the scheme provides who will deal with what, and it's very impersonal. So therefore, if my assessing officer, who is acquainted with my affairs, he has assessed me from year to year, he has my return with him, he has seen what kind of income I have shown, but it does not appear to make that allegation that this whole thing is kept outside the books, particularly where tax has been deducted at source from that amount. But somebody has to be very brave not to a risk taker, a real risk taker. Not that income, I receive interest from the income tax department, but I receive money from it, a large sum from it, the tax has been deducted at source, I keep everything outside the books. So that's why the challenge is there, because the information must suggest escapement of income, not just any figure in the information that it's such a large figure, therefore let us go for this. So that's how the challenge comes from. So kindly see at page 162. I was showing, yes. Now the return proper starts at page 163. If I may draw attention to page 186.
Page 186.
Lordship, this is the heading. Kindly have a look at trading account. This is part of the return. Trading account for the financial year 2021, applicable for companies' financial statements are drawn up in compliance with Indian accounting standards specified so and so. Revenue from operations. Actually, it starts at page 185 at manufacturing account, and then the trading account is at page 186. Kindly see sale number 4, revenue from operations, Roman II, sale of services, 384 crores. Now, then kindly take note at page 188. Serial number 15, total of credits to profit and loss account, 468 crores, which includes the 384 crores. 384 crores is at the top. And total credits to profit and loss account, therefore the credit side of the profit and loss account is 468 crores, which means all the credits. My lord has found it.
Yes. Item 15.
Lordship. Then kindly see at page 490.
490.
I'm sorry, 190. I'm sorry, 190. Serial number 53. Net profit before taxes, 223 crores. Then at page 199. This is the computation of income from business or profession, note at the top, note, schedule BP.
Yes.
Note the figure of profit before tax as per profit and loss account, 223 crores 53 lakhs. This comes from page 190. And note that is the figure here. And then note at page 201. In fact, note page 202. Income, capital D, note, alphabet D. Income chargeable under that profits and gains from business or profession, 177.94 crores. So note this was the business income.
Page 202.
202, note D, alphabet D. Yes.
Yes.
Then note, if I may take my lord to page 229. Right, this is the deductions under chapter 6A.
Yes.
And here my lord will find out serial number 2 F 80 IB 163 crores 82 lakhs. And then look at page 233. This is the computation of minimum alternate tax payable under section 115 JB. The final figure is at the next page, page 234, serial number 9. This that 179 crores was the book profit. Now I'm going to kindly take the computation of total income, page 249. And just the prior page, page 247 once more. This is information regarding turnover gross receipt reported for GST.
$247.
Yes. This is 320.57 crore. No, that is the turnover which I have reported for GST. No, for the purpose of taxation. Then we're at page 240.
This is all to show that it could not have been out of books.
No, it cannot be. No, because if they had actually cared to look at it, no, the difficulty is not they simply because there's a dispute they want to raise regarding the head of classification of income, but they have gone on to say that it is outside the books. So it is page 249, if my lord is please see computation of total income. Two forty nine. Nine. Yes, the schedule TI computation of total income. Serial number 2 profits and gains from business or profession. That 177 crore which is there in schedule BP. Then kindly similar 11 serial 11 B chapter 6A deduction is 163 crores. Serial number 15, income chargeable to tax at normal rates, 13 crores 40. And look, page 250, deemed total income under section 115 JB, 179 crores. Now look, then the tax liability gets computed note at page 251.
Yes.
But kindly see serial number 10, taxes paid, B, TDS, 22 crores 58 lakhs 80,000. Some of the taxes which is deducted, no, that is claim credit here. So therefore, this is the return, and look in the computation which is at page 255, note that we are more used to looking at that. Note the at page 255, the same thing is not projected in a summarized way. Not the same figures, not which not then ultimately they're broken up into SEZ, IT Park, and then what is the and then what as far as the audited accounts are concerned, but they start at page 270. But kindly take page 271. It is the profit and loss account. But, revenue from operations, the heading is statement of profit and loss, not the for the year end 31st March 2021, revenue from operations, other operational income, profit loss, not these are the figures on the basis of which the return was filled up. So these are as per the return. But I wanted to show here the interest from the income tax department. Well, kindly take note volume 3, note at page 285.
Page
285. Well, this is the breakup of the revenue from that first part is breakup of revenue from operations, note that rent and maintenance, note that is the breakup is given 384 crores, and then what below that breakup of other operational income, note this B, alphabet B.
yes.
Note A is interest from banks on deposit, B is other interest. This 44 lakh 34,717. Well, this is the amount of interest I received from the income tax department. So this is specifically here they have proceeded with reference to a lower figure of 44 lakhs. But I shall show from the notice the exact figure. But no, the precise figure is not 44 lakh 34,717, and this is not in my books there. So no, this is my
Mr. Kesan, just for the purpose of understanding, this
Gotcha.
breakup of revenue operations also has this IT column. Was this then how do we reconcile these two? This interest income, uh, the first block of breakup of revenue operations,
Mallet,
which has sale of services.
Lordship.
So what does this figure indicate under the head IT?
But SCZ is a special economic
Is
zone.
that
IT
clear?
is the IT part, which is not inside the
And
SCZ.
this here this in the second block, the one which you now indicated, 44,34,717.
Yes, kindly see the heading above the second block. Note number 19, other operational income. Breakup of other operational income. Under that note,
Okay, but this also comes under the head IT. That was actually confusing.
yes, if I may trouble my notes once with schedule 2, I'm sorry, volume 2, and the profit and loss account there, at page 271. Because the exemption is for the SEZ, so therefore that they were showing it separately.
271.
Yes, ma'am. 271. Can you see at the top? Revenue from operations 384.05. Other operational income 8 crore 47 lakhs 58,000. And that breakup of that 8 crores 47 lakh is, so they are showing that it relates to which part of the business, SEZ business or the IT information technology business. So therefore they have broken it up into two segments, and the
interest which was given by the income tax department was in relation to that
IT.
information technology.
Yes,
business.
yes. So therefore this was the that's how they, because the exemption they can claim, deduction they can claim only with reference to that SEZ. So therefore they have to maintain that segregation. So this was the state of the accounts and the return. Now and we have this was return was processed under section 143(1), which is at page 436 of volume 4.
Or 36.
Gotcha.
Yes.
That page 436 is a summary. Page 437, they have mentioned serial number 2, income under that, profits and gains from business of profession with 177 crores. And then the deduction under chapter 6A, serial number 712, B, 163 crores. And then as far as the heads of, and then the tax liability, all that is worked out. At page 438, serial number 39, B, TDS, 22 crores. And then at page 440, mismatch between tax credits claimed and allowed. So they compare my return with the Form 26AS. And the reason for mismatch, they mention Form 26AS. So the comparison they make with Form 26AS, and so if there's a mismatch, the credit is to that extent. So this is a small list of some few lakhs which was not allowed. So they processed and accepted my return. There was a rectification under section 154 or at page 465. And but this with this also, there's a page 470 is the mismatch tax credit. So therefore, they have looked into the credit part, the income part, and all that. Then the comes the 133.6 at page 480.
Yes.
No, this is 22nd April 2024. Income tax department notice under section 133.6 assessment year 21-22. Income tax department is in possession of following information about your financial transactions for financial year 2021, which assessment year 21-22, which could have an implication on your taxable income. Interest from income tax refund 43,47,060. Rent received 264 crores 12 lakh 838. Now paragraph 2 is important. The details, particulars of the aforementioned information are available in annual information statement and may be viewed by logs. So their source is just this annual information statement. It's not that they have any information or anything from outside. It is this only. And then kindly see at page 481 the queries. Information called for. As per information, you have received interest on income tax refund as mentioned on the front page of the notice. Please reconcile the interest on income tax refund with the income offered by you in your return of income, if any, assessment you mentioned above. Documentary evidence for the expenditure claimed, this means not relevant. Then 3. In case rent from house property is not offered under the head income from house property and is offered under any other head of income, please explain the reasons for the same. 4. Please furnish reconciliation of your rental receipts with the rent reflected in Form 26A and income from house property shown in return of income, if any. This rental receipts, so they are on this house property. Then the answer is at page 483.
Yes.
But question 1 is regarding the interest on income tax refund. The answer is the above interest has been offered and interest income in PL part of ITR and the amount offered is 44,34,717. So that is the figure note which I had shown to my lord from that. And then at page 484. Please inform whether you are sole owner, joint owner of each of the properties. The assessee is infrastructure developer. It carries on the business of developing, operating and maintaining IT parks and SEZ. This requires developing of the infrastructure facility and leasing and maintaining the same. In the year under question, the assessee was eligible and has claimed deduction under section 80I-AB. As required by the provisions, the assessee is required to offer the amount received from profits and gains from business or profession and not under income from house property. The question raised through this notice presume taxability under income from house property, and so we therefore request you to kindly consider our above submission. The property is divided by meets and bounds, and the assessee is the sole owner of the property described. Income generated therefrom is therefrom in the audited financial statements, ITR GST1. So they make that specific statement that it is in the financial statements. And number 2, please furnish the monthly rent and the total rent received. It appears that the notice is issued with the presumption that the assessee should be chargeable under the head income from house property, which has been addressed in our response above. The rentals received has been reported appropriately under profits and gains from business and profession. The PGBP is an abbreviation used for saying that it is profits and gains of business profession in the ITR. And then the query number 3, please furnish reconciliation of your rental receipts with the rent reflected in Form 26A and income from house property shown in return of income, if any. Now, I had not shown anything under head house property. So response was explained, as explained previously, assessee being a developer of infrastructure facilities and in the business of developing, maintaining and operating IT parks and SEZ, such activity uh, has been held and accepted as business income. Unlike a passive activity falling under income from house property, rental receipts reflected in Form 26AS has been appropriately reported under profits and gains of business or profession. And what the query number 4, in case rent from house property is not offered under the head income from house property and is offered under any other head of income, please explain the reason for the same. As explained above, the activity of developing and maintaining and operating of infrastructure facilities such as IT park and SEZ is not a passive activity chargeable under income from house property, but a business activity, therefore rightfully offered under profits and gains of business or profession. Furthermore, in the year in question, as the SSC was eligible for claim of deduction under Section 80 IAB, the income as per the requirements of the provision ought to be reported only under profits and gains of business or profession. And then what the property description, etc. Then we're at page 486. This was they only raised a question regarding this amount of interest income. As per information available with us, the total amount of interest and refund received by a company during financial year 2021 is 43,47,060. In the ITR filed by a company for assessment year 21-22, the total amount.
Ultimately, the reopening is only with respect to that 264 crore.
Also, the interest. Kindly similar to page 489 is the 148 notice.
Yes.
And then the approval, page 490. And what
492 is the annex.
Yes, ma'am. And what paragraph 3.
Yes.
Information. They refer to the return in paragraph 2. On verification of this office record, it appears that the instant SSC has filed its original return of income electronically under section 139(1) on 20th January, disclosing total income of 13 crores 40 lakhs. Information at
3 only states about 264 crores.
Yes. So this 264 crores 56 lakhs, it comprises both, which the original 133 notice said. That is 264. In my lord is pleased to have that particular notice. That page 480.
Achha, because it was 264.12.
Yes, ma'am. 264.12.
Now it becomes 264.56.
Yes, ma'am. So page 480,
so
my lord will see.
3 is added.
Yes, ma'am. So both are there. And this is not the sum and substance. Paragraph 3. Information has been received from the CBDT in the case of incident assessee through departmental insight portal under the category of high risk e-verification scheme, wherein it was reported that the incident assessee had failed to disclose an amount of rupees 264 crores 56 lakhs towards interest from income tax refund and rent received during the financial year 2021 in its books of account and hence evaded taxes accordingly. So and then they refer to the provisions under which they can straight away issue the 148 notice. So this is the then the objection was filed for that page 521. Just some 2 or 3 portions, if I may show. Paragraph 3 at page 522. The middle, just above the middle of the paragraph note, as per the annexure provided along with the approval under section 151, the assessee had failed to disclose an amount of 264 crores 56 lakhs towards interest from income tax refund and rent received in its books of account and hence evaded tax accordingly. However, no such information has been annexed to the said notice or provided to the assessee. Without providing the assessee with the aforementioned information basis which the impugned notice has been issued, and the failure to adhere to the mandate laid down in section 148A, which has been dispensed with, renders the impugned notice to be bad in law. And then in paragraph 4, mention is made of the 133.6, which was issued and answered. And then they've answered on merits to say that it's all there in the books. It's not that any of it is outside the books.
Yes.
This they have not disposed of.
Disposed of.
They think that it's not required of them to take this particular route. So clearly that 133.6 query and answer does not find mention anywhere here, because if they had taken that into account, they would have perhaps not made this allegation that is outside the books of account. Now that Bombay decision, if I can. There was a question mark about the interest earned from the bank. So the department thought it was a much larger sum, and that was again not based on that information under 135A. So kindly similar that page 719. The paragraphs 23 onwards. This is not the. If my lord permits me, I can place the whole of it, or.
Paragraph 25 is spot on.
Yes, ma'am.
On 133.6 information and application.
Yes, ma'am. That
Page 720 placitum B.
Yes, ma'am. That is between C and D. That is the precise passage.
Yes.
No, I mean, there are two or three other decisions, but one is of the Honorable Allahabad High Court, which is purely on the basis of GK and drive shaft, that the that is not
Principle
done away
applies.
with. That is not done away with. And
Bombay High Court has not spelt out on that. No.
no,
He has not spelled.
they actually the facts, because the facts took a different
Yes.
turn, the revenue accepted. Therefore, it became. But the court has observed that one should.
Application of mind will also be apparent only if it is disclosed. Otherwise, I can apply my mind and then also I can issue a notice. But if I keep the product of my application of mind to myself,
Not
how would the other person know as to whether mind has been applied on it, or because it is only the product of the application of mind being on the product being communicated to the other side that one would get to know whether application of mind has been done or not.
Not sure.
It may not be application of judicial mind, but has to be application of
Not
to the
And-
matter.
If I can trouble my lord with the section once, when this speaks of information, that information in section 148A subsection 3, Roman 4, any information made available to the assessing officer under the scheme notified under section 135A. Because subsection 3 starts with, for the purpose of this section 148A, the information with the assessing officer which suggests that income chargeable to tax has escaped assessment means any information made available to the assessing officer under the scheme notified under section 135. So therefore, that information cannot be bare information. That information must give rise to that. Yes, there is a fiction, but not the fiction will operate only when that information on its own suggests that there is income chargeable to tax has escaped assessment. Not any, because that information of what amount of tax has been deducted from a certain amount of income, that itself is not the information on the basis of which that one can proceed on the basis that income chargeable to tax has escaped assessment. So therefore, it is not information simply straight. It must flow from that information, and they must have something to say that this has not been subjected to tax. Therefore, there has to be the information must suggest, therefore, that information and the escapement of income, there must be a nexus between the two. Not here, that is not totally not there. Normally, that Allahabad judgment, my lord will find out that in under paragraph 8, the GK and drive shaft is, this was also a search case. Therefore, the search is an exception. Can you take note paragraphs 9 to 12. 9 onwards. The there's a judgment of the Honorable Delhi High Court, where it was again not based on information obtained under section 135A. Assessee filed an objection and the revenue decided it. So that they did it on their own. But what had happened was that they had enclosed a wrong annexure in the information part, which was not meant for the assessee at all. So the court permitted substitution of that information and then said, now you file objection and they will deal with it and thereafter proceed. So the department itself, therefore, it was not really contested there that objections need to be decided, but I'm showing what the department itself did. But paragraph, opening paragraph note at page 2, the first paragraph, it notes not dispose of the objections, and paragraph 2,
Disposed of the objections dated such
yes,
as.
yes, and paragraph 2, it is that information collected under section 135A, and then in paragraph 15, if my lord is pleased to have it. That it was a wrong information. Assessee wanted the whole thing to be quashed. The court said no. Let them give you the correct information, and then you will. Paragraph 17 and 18. The reliance is on the Bombay High Court judge.
Yes.
But the last one of the Punjab and Haryana High Court, here again, my lord will find the paragraph 15, where they agreed with the Bombay High Court note. And 16, in that case also there was a 133(6) notice. Just that GK and drive shaft, I'm not kind of a copy of that. But in some cases, it has been held that the 148A codifies the view take, but that the exceptions did not call for consideration in those cases. There's a decision of our division bench also where they extracted, they summarized the view taken by the Delhi High Court in Divya Capital 1, where it was held that it codifies. But this controversy was not there in those cases. Where it actually arose, this is the view taken by the judge.
And Mr. Ketan, so far as that challenge to the constitutionality of that is concerned.
Well, so if the constitutionality challenge is based on this foundation that if the law permits them to reopen on the basis of information simpliciter, which does not suggest that income chargeable to taxes escape assessment, they simply go on the basis of the fiction.
So we will go to the constitutionality aspect if the revenue is able to cross this hurdle which has been put up first.
Yes, yes.
The hurdle that this notice under section 148 could not have been issued because of these reasons, which we have just now stated in detail, that it suffers from the incorrigible vice of non-application of mind, because there are facts which ought to have been taken into consideration, and if the authority had taken them into consideration, it would not have jurisdiction. It would not have had jurisdiction to issue notice. So, decision of fact to assume jurisdiction is wrong.
Yes,
and that also gives rise to a jurisdictional error. If the authority gets over this, then we'll go into the
Lordship.
Yes.
Not your lordship has seen the assessment, everything, all the documents your lordship has seen. So, my lord, your lordship has seen the assessment order, and also, my lord, so main thing is not there was a mismatch between the thing according to the department as per section 135 capital A, since the provision is there, it can be done, and 136 notices were issued. They have filed their reply. They were asked to produce certain documents. What they have done, they have given a balance sheet. In the balance sheet, profit and loss account, they have figured it out 384 crores. They have not bifurcated that. That was the contention which was taken. Since they have not bifurcated, it was found that 264 crores was not given in the, therefore